Hello everyone and welcome to today's Mondat webinar in association with Keltie LLP. Experts from Keltie will provide a comprehensive overview of how to identify, best protect and monetize your IP assets, particularly within the AI and computer space. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Kimberly Bayliss is a partner at Keltie. Kim has been at the forefront of the AI technological wave and has helped shape the strategy and AI patent portfolios of several of the world's largest patent filers. Kim was rated as a rising star by Managing IP in both 2022 and 2024 in recognition of her expertise in this area. She has spoken widely on the subject and was an invited speaker at the recent WIPO KIPO interactive online workshop on AI and IP. Colin Patterson is a partner at Keltie. Colin's professional experience spans a variety of technical areas, but he has particular expertise in software and mathematical-based technologies, such as artificial intelligence and machine learning, applied across a variety of industries, including drug discovery, gaming, and engineering. Having worked with a range of different clients from individuals and SMEs to multinational corporations, Colin has extensive experience in drafting patent applications, portfolio management, and patent prosecution across many jurisdictions. Before I begin today's webinar, some housekeeping items. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page, and we will endeavour to answer as many of those questions as possible. But please do get in touch afterwards for any additional information you may require. It's now my pleasure to hand you over to Kim and Colin to begin. Thank you.
Thank you so much, Dan. And yes, great to be with everybody today. Thank you very much for joining. I hope that over the next hour or so we can provide some useful tips for you to take away. And I think we've got quite a variety of backgrounds of types of people joining us today. So hopefully there will be something for everybody, and we can take it from there. So as Dan said, we are going to run through some considerations and tips around developing an intellectual property strategy that makes use of the different IP rights that are available in a manner that is most strategically useful for a business and your company. Now, as many of you will know, there are various types of different intellectual property right available in order to protect different types of IP assets that might subsist within your company. But the important thing to note is that these IP rights are no more than commercial tools, and they should not be used simply to protect assets just because they can. And it's sort of in that way that IP protection becomes just a cost center to a business. Rather, your IP rights should be used in a more strategic way to improve your company's position in one way or another, whether that's to exclude third parties from entering a certain marketplace, or to increase company valuation, make it more attractive to investors, that sort of thing. And it's this way that the investment you make in IP protection actually acts to grow your company or increase profits, and doesn't just act as that sort of cost center. So here's a rough summary of what we'll cover today. I'll start by looking at how you might actually identify what IP assets you have in a business and working out how to go about protecting what first and in what order and with what priority, and looking at the most appropriate form of IP right in different cases. I'll then hand over to Kim, who will take you through the other points relating to the monetization of those IP rights, and actually putting in place a strategy to actively increase company valuation using these available rights. So where do we start? it's a good place to start with thinking about how your activity in around protection of IP fits in with your overall business strategy, and the two really should come together. And different businesses of different sizes and different types in different areas of different industries have different priorities and what they're trying to achieve. So, in the startup space or the SME space, a business strategy may be that you're looking to simply maximize the valuation of a company with a view to exiting within a certain number of years, within 5 years, for instance. Then what do you do on the IP side? Well, your IP strategy might involve filing several patent applications across all different areas of the business that cover various novel aspects and processes that the company might be undertaking in order to maximize that inflation of valuation and to give potential investors confidence that what they're actually investing in is protected and a sound investment. On the other hand, if your company is actually intending to develop and take a product to market or a software tool, not just a physical product, but you're looking to take something to market, then your IP strategy may be slightly different, where you first need to actually conduct due diligence to ensure that you yourself have freedom to enter a certain marketplace and operate within that marketplace before then actually taking steps maybe to protect novel and clever parts of the product that you're taking. Similarly, you may just be an R&D company without any plans to sell a product necessarily, but your income stream is going to be through licensing deals. Then you really want to make sure that the subject of those licensing deals is going to be protected in as an appropriate way as possible. So it's a good idea to actually put together a document that outlines your IP strategy. Now, in some cases, this could be a one-page document, but it just puts down in writing exactly where your priorities are. And share it with other people in the company so that everybody is aligned. It's a good idea to set aside a budget for this. I think particularly in the UK and Europe, it's quite common for budget for IP protection to just be consumed or included as part of a more general budget for legal. Whereas I would say in the US, there's more of generally an acceptance that investing in IP is that it's not looked on as a cost, it's a necessary part of building a business, and it is an investment which will actually, done properly, act to grow the business and increase its valuation. And by having an IP strategy with a defined budget, that can help you to prioritize what needs to be done and to decide exactly what you can do within that budget. No company in the world can do absolutely everything and protect absolutely every aspect of the business. So it's not black and white. It's more of a case of prioritizing what is important. So in terms of actually identifying what you've got and working out what to protect first, the very short answer is whatever most aligns with your IP strategy. Now, how might you work this out? The sort of considerations appearing on the slide here are sort of from the point of view of possibly an innovation-based company, maybe particularly looking at software, AI type subject matter. Separate to this, we also have, of course, other forms of IP, such as branding, whereby you can use trademark protection to protect. But if we're looking at sort of innovation within a company, these are the kind of considerations you might be looking at. Now, I would say most people understand that, you know, for patent protection or design protection, registered design protection, this concept of novelty is important, where you have to be doing something new over and above what has come before. But what is perhaps not so well understood, or is not given enough thought, is then actually thinking about how that fits in commercially to your business. So you might have this lovely novel process or product, but if ultimately it's not going, protection of that novelty is not going to be that commercially useful to you, then you do have to question exactly how you fit that in with your IP strategy. And another important point that is often a misconception is around what something like patent protection actually does. Now, you might often hear the phrase, "Oh, I've patented this product, or I've protected this product with a patent." It's often the case that a single patent will only protect one specific aspect of an overall process or product. And so if you have a more general product with lots of things going on, you may actually need several different patent applications to cover off the several different novel parts of that product, rather than just having one single catch-all patent. So it's important to understand exactly what you would get by filing a patent application on a product, and exactly what would be protected. A question around that often comes up around AI and other more general software subject matter is, well, okay, if I have a patent granted to my software tool or my AI tool, I'm never going to be able to tell whether a third party is infringing, so what role does the patent play? Well, it sort of comes back to what your IP strategy is and how that fits into your business strategy again. You may have no intention of ever actively enforcing granted patent rights against a third party. Your patent filings may simply be to increase the valuation of the company and prepared to give confidence to investors. So again, this is a consideration you have to take, but depending on what role a patent application is going to play in your overall strategy, then it might still be the right decision to proceed with a patent filing. And of course, again, most people understand that patent applications come before any public disclosure of your idea. And so when you're working out what to protect first, that may be driven in large part by planned disclosures of certain aspects of your business, whether that's discussions with collaborators, presentations, website publications, etc. But essentially, you want to prioritize commercial value over, and what gives you most sort of bang for your buck, if you like, over just how good or revolutionary you consider your technology to be. So, as mentioned, there are various different forms of intellectual property right available. Some require you to go through a formal registration process, such as patents, such as registered trademarks, registered designs. Others subsist somewhat more automatically, such as copyright, at least in Europe, as well as confidentiality or trade secrets. And when it comes to sort of AI related innovation specifically, often there is conversation around the trade-off between patents and trade secrets, and which is the best form of protection. Often it can be a combination of both. Patents protect functionality of products and processes, whereas trade secrets can be used for implementation details. So patents can protect the broad functionality of your software tool, for instance, but you don't want to disclose the specific implementation details to implement your product. And so you might keep those details in-house. And if we're talking about source code, for instance, then actually copyright might also be relevant in this regard. But it should be noted that in this sort of context, copyright can be regarded as quite a narrow right, in the sense of it just protects the specific implementation rather than the general function, and can be difficult to enforce because, as the sort of name suggests, you would need to prove copying to enforce copyright infringement. So what I will do over the next couple of slides is outline some of the factors you might take into account when weighing up whether to go down the patent protection route or the trade secret protection route. And on this first page, coming to patents first, it's not just a formal registration process that you need to go through to acquire granted patent rights. It's typically pretty lengthy. The sort of standard would be 4, 5, 6 years, even from the initial filing of your application through to grant. And while there are generally options to accelerate if needed, then that would be a typical timeline. But that's actually not necessarily a bad thing, because while you've got a patent application pending, you've got your stake in the ground, so to speak, with your filing date, and while the application is still pending, you have flexibility to amend the scope depending on the direction that your own internal R&D development may take, but also what's happening out in the marketplace with third parties, and ensuring that you end up with the scope of protection that's going to be most commercially useful. Patents, like pretty much every IP right, are territorial in nature, so you do need to go through separate examination processes in each different territory in which you want patent rights to be granted. And this sort of feeds into one of the other points, which is costs. Patents can be relatively expensive, particularly if you're going for more widespread territorial coverage. And so you need to think carefully whether that actually is going to be a good investment. And again, it comes back to what you're looking to get out of your IP strategy, but spending tens of thousands of dollars or euros or pounds on obtaining widespread patent protection, if it pays you back in an increase in hundreds of thousands or millions in terms of company valuation, then it is a worthwhile process. One other misconception that arises quite often is around what patent protection actually gives you the right to do or not do. It can be thought of as an exclusive right in the sense, or a negative right, in the sense of it gives the patent owner the right to exclude third parties from performing acts such as making or selling the protected process and invention. What it does not necessarily give the patent owner the right to do is actively work their own invention. And it's sort of a subtle difference, but you can get overlapping patent rights where two competitors can actually both prevent one another from going to market with their respective patent rights, which opens up the possibility of licensing deals and those sort of things. Patents are no more than a property right like any other property. You can buy, sell, license, etc. Again, when it comes to the AI and software space, the question of patentability is an important one. There are some excluded categories in terms of subject matter in Europe of categories of invention that are excluded from patentability, and you need to be careful to navigate around these. But broadly speaking, if you are using your product in what would be regarded as a technical way that, and you're solving a technical problem, then there is a good chance that your invention will be patentable nonetheless, save for all the other requirements. The disclosure requirement is an important one as well. So you need to be aware that when filing a patent application, it will enter the public domain after 18 months or so, typically. And so you need to be comfortable with that. And it feeds into the next point there, which is that eventually there is a possibility that a patent application could be refused, but is nonetheless already now in the public domain. Or even if it's not refused, it may be granted with a scope of subject matter that, or a scope of protection that you didn't initially envisage, and maybe slightly narrower. So you need to sort of weigh up the benefits and risks in that regard. But having said that, if you get granted patent protection, it can be regarded as a relatively strong form of protection that has been through a formal examination process and will stand up, hopefully, to challenges. And then once you've got these rights, it gives you leverage. You can choose what to do with them, whether that's to enforce or to license or to sell. So in that regard, it gives you flexibility. Now I want to come back just to the disclosure point associated with patent applications again, and this sort of comes back to the patent bargains that's sometimes referred to, which is that in return for a patent holder receiving exclusivity over a defined invention for a period of time, up to 20 years. In return for that, they need to disclose publicly how to carry out the invention. This is referred in Europe to sufficiency, that your patent application must describe sufficiently clearly and completely how to actually work the invention. And what we've seen over the past couple of years is that bar to achieve sufficiency might be slightly higher for AI-related innovation. And there's been sort of some case law that's come out of the Board of Appeal of the European Patent Office, which has refused applications for not including enough detail for how to actually put a claimed invention to work, for some of the reasons shown here. Input data into an AI model is not disclosed sufficiently, the model structure is not disclosed sufficiently, details of input vectors, number of neural network layers, etc., not disclosed sufficiently. And it's the bar's higher possibly because we're looking at more probabilistic type subject matter rather than deterministic, And so you need to work a little bit harder to show that, to explain how to implement an invention when it's not just a nice sequence of ordered steps, but there's a little bit more of the black box going on around it. And there has been a very recent decision as well come out of the EPO Board of Appeal, which again clarifies and further emphasises that detailed disclosure of your machine learning model is needed. Clear definition of input and output variables, training data, and the quality of the training data, if that's going to be necessary to actually work the invention. And the disclosure requirement is not just relevant for sufficiency, but also possibly another requirement to get granted patent protection, which is to clear the hurdle for inventiveness. In Europe, we sort of regard inventiveness as thinking about it from the point of view of if you're solving a technical problem and achieving a technical solution, and what the sort of technical effect of your invention is, of your claimed invention. And whereas for some types of subject matter, including more deterministic type software subject matter, previously it may have been enough just to assert your technical effect in a patent application, but you might need to work a little bit harder than that to evidence technical effect for AI subject matter, particularly if it's only achieved for certain types of AI model when certain types of input data is used, etc. And so this disclosure requirement is another thing to consider as to whether you might want to file a patent application or not, because that level of detail either might not be available to you in the company yet, or you might not be comfortable with disclosing that in a patent application. So then moving on to trade secrets, unlike patents, there's no formal registration requirement, but actions still do need to be taken to ensure that some of your IP assets would be regarded as trade secrets if needed. As in the name, a trade secret needs to be secret, but also it needs to have commercial value because of the fact it is being kept a secret. And you need to take reasonable steps to keep it secret. Now, it's more of a risky form of protection in the sense that if your secret enters the public domain, even maliciously, there's no sort of rolling back the clock to then put it back in a box as a secret. The game's up by that point, even if you might be able to try and enforce trade secret protection. The secret itself is nonetheless out. So it's important to keep an internal register of trade secrets to ensure that anything you consider to be a trade secret will be regarded as such. This document or register should be updated regularly to take out stuff that's no longer a secret. It should be a simple and clear process. While a trade secret register is okay, it's only as good as how often it's updated and who is updating it. A practical point of actually how to maintain a register is not to chuck everything in. If it's the old adage of everything's important, then nothing's important. And it's the same. If everything's regarded as a secret in the company, then really nothing is any more secret than anything else. But once you've identified something that would be regarded as a trade secret, then you might want to keep a register, maybe with a title or a short description of the secret and who has access to it, but then just a pointer to where other details about that secret can be found. If you try and keep all the details of every secret in one place, then it's more likely that this will not be kept up to date sufficiently. Other tips around trade secrets: it shouldn't just be, even though there's not a formal registration process, there's a temptation just to regard trade secrets as the cheap option compared to patents. But it's important to know that it's a separate type of protection for a separate type of subject matter. Have a policy for what's marked as confidential and what's not, for a similar reason as before. If everything's confidential, nothing is. In terms of employees and trade secrets, it's a good idea to have a policy around trade secrets that you might require employees to sign, and also leavers, employees who are leaving the company, to sign, so that they understand their responsibilities around trade secrets that they're aware about, but nonetheless belong to the company. Similar, when onboarding a new employee, actually, you might want to ask about details of any patents they're an inventor on, as there may be trade secret information from their previous company that goes alongside that, and you need to be careful not to overlap and risk potential trade secret infringement. And you can set up sort of alarms and alerts, for instance, in your document management system to alert you when large amounts of data has been accessed or downloaded, for instance, and this might put in an extra level or layer of protection around trade secrets. So, as is often the case, the answer to what form of protection should I use is it depends, but briefly summarising, patents can be regarded as a strong and safe form of protection. So it can be a good idea, especially within an IP strategy, where you need to take things to market or to increase valuation, to look at patent protection, while bearing in mind some of these points here around the costs and the risks of not being granted, and also the relevant disclosure requirements, particularly around AI subject matter. And then perhaps you might use confidentiality to fill in gaps around that. Okay, at which point I'm going to hand over to Kim to take you through the next part.
Thanks, Colin. Okay, so in the second half of the webinar, I'm going to do a bit more of a deep dive into how to make your IP portfolio really work for your organisation. So I'm going to go through some different ways of monetizing, different types of IP assets, and then we're going to talk quite a bit about how to link them back to your business plan and your business strategy, and also how to make sure that any filings that you do make, patents filings, are really strategic in nature. So I'm going to start off with a bit about monetization. And I'm actually going to start off by talking about how to monetize trade secrets. And the reason for that is that I went to a conference recently where I spoke on monetizing trade secrets, and I asked questions to the audience, and I said, how many of your organizations have like a really good policy about how to determine whether to monetize a trade secret? And only 11% of the delegates thought that they had one of these sorts of policies in place. So I think this is probably a really underutilised area, or under-considered area of IP strategy. Right. I can't change slides. Colin, I think you might need to move your mouse off the main bit there. Aaron, is that working?
Try it now, Kim.
Yeah, okay. Sorry about that, guys. Okay, so we're talking about trade secrets and licensing trade secrets. Okay, so the first question is to license or not to license your trade secrets. So there are a lot of different considerations that you might think about when thinking about whether to license or not to license. And a couple of them are just here, a couple of the key ones are here on this slide here. So a couple of things you need to think about. How easy is it to keep your trade secret a secret? How commercially valuable is it? And when you're thinking about that, obviously you're making a normal risk-reward sort of analysis. And then you also want to think about how will its value change over time? That is the value of the secret. So depending on where your secret sits within these questions, you might come to different conclusions. So for example, if you've got something that's easy to keep a secret, it's commercially key and it's got longevity, so it's going to be valuable for a long time, then perhaps you're lucky enough to be sitting on a Coca-Cola recipe style trade secret. Something that you just want to keep in-house, you want to protect, as much as you possibly can for as long as you possibly can. If you've got something that's harder to keep a secret, perhaps some information about the secret is leaked every time that the thing is used or sold, that might be a different case. So these types of secrets might still be really commercially valuable, but they might have low longevity because of this leakiness of the secret. So in that case, you've probably got like a fairly isolated window in which to make this type of decision. And again, you might decide to keep it your trade secret in-house and to use the market edge that it gives to give you an advantage in the market, or you might decide to license in that sort of case. And of course, there are other different permutations of those as well, but I think those are three of the kind of key questions to ask. Okay, so just moving on to some things to think about when you're putting together a licensing agreement for a trade secret, because these are a different beast to other licensing agreements that you might be familiar with. So for starters, you need a clear definition of what the trade secret is that's being transferred. And you probably don't want that in the agreement itself, of course. You might want to put that in a separate document and just refer to that document in the actual licensing agreement. You might want to describe or have some clauses that talk about the obligations that are placed on the licensee. So for example, if one of your trade secrets is a new method of manufacturing, so perhaps you're in a factory setting and you've got this trade secret method of manufacturing something, you might have the production line behind a screen, or you might even have it in a separate room with like a keypad entry or something like that. So you might want to stipulate in your licensing agreement that the licensee has at least that same level of protection in place for the secret as that you do yourself. And then, of course, you're also going to want to stipulate in the licensing agreement what the licensee should do at the end of the period of the agreement. So when the licensing agreement ends, do you want them to destroy that production line? Do you want them to delete certain documents off their server? That type of thing. These are the types of clauses that you want in these agreements. Oh, sorry, we've just gone past a slide there. But a couple of other key clauses that are important in your licensing agreements are you want to make sure that that you can actually audit those clauses as well. So, for example, if you've got a clause in there that says what the licensee should do at the end of the licensing agreement, then you want to also give yourself the right to go in and to check that that's been done. So check that documents have been deleted, check that the production line has been destroyed, that type of thing. Okay, so talking now, moving on from the licensing agreement to the payment structure. So in licensing trade secrets, you might want a different payment structure to traditional licensing methods. So, for example, most of the value of trade secret licensing happens when there's that transfer of knowledge, when the secret is told to the licensee. So from that point of view, you might want a large initial upfront payment at that point, and then the ongoing royalties payments might then be lower over time. They might be tapered, or they might just be set at a generally lower level. And that large transfer of the upfront payment obviously coincides with the point of maximum risk really to the licensor as well. So that's obviously a little bit different to how other licensing agreements might be structured. Okay, and then just as the last sort of point on this is that there are obviously risks associated with licensing trade secrets. And the main risk is that the licensee leaks the secret. So like Colin said, once it's out there, it's gone. And another risk is that the licensee gets all of your company confidential information. They might then be able to develop around it, or develop their own new process, and that's a risk as well that needs to be weighed up. So moving on to patents, patent licensing is obviously very familiar to lots of people. It's a well-trodden path for monetizing a patent application or a patent granted patent. And you can license to a subsidiary if you want to keep the benefit within your group of companies, or you can obviously license to a third party. And again, you need to think carefully about the royalty structure of the license, and that will be different in comparison to your trade secrets. So you might have like an ongoing payment that's slightly higher, and that reflects the fact that the benefit of licensing a patent is that is the ongoing monopoly that's provided. There isn't like one single point of transfer of benefit. But there are lots of other ways of monetizing patents. So you could join a patent pool. So this is where a group of patent holders come together and that they license a group of patents together and then share the royalties from that license. And this can actually be really good in promoting your technology, particularly if it's to do with related to a standard. So you can encourage the adoption of a particular technology standard, so something like an encoding standard for encoding data or something like that, by presenting the market with an attractive patent pool. And this has been done with great effect in lots of different areas, from telecoms to like I said, in encoding standards for broadcasting media. You can also make money through enforcing your patents. Obviously, non-practicing entities do that type of thing. You can sell and mortgage your patents as well. Another thing that's perhaps less well known is that some large organisations actually have dedicated departments where that they fund R&D. And the only goal of that R&D is to generate patents that can then be licensed by the department. So essentially, you almost have patent sales teams who are just generally who are looking to fund patents that they can then license on. And these can be extremely profitable departments of larger organisations. There are some others that were on the slide that's unfortunately skipped over. That are perhaps more relevant to smaller businesses. So for smaller businesses, they might be able to use their patent income as a security against a loan. So if you've got royalties, for example, from a music portfolio, if you've got licensing of music, then you could use that in order to get a loan and use the ongoing royalty payments as a security against that. So moving away from patents now, another area where that you can use your IP to your benefit, or perhaps more broadly here, perhaps this is your R&D efforts to the benefit of your company, is through actually open sourcing. So some organisations have been really successful at providing some of their code base in particular as open source code to the market. And again, this really encourages the use of proprietary software. And then off the back of that, you can use that to sell your consultancy services, for example. So organisations like Red Hat and HP have been successful in doing this. So strategically making some code available under open source licenses can be really, really good and beneficial. So one thing that I'm really interested in is monetizing data. So as Colin said, we're both interested in AI. And in the field of AI, data is so valuable for training machine learning models. And when I'm talking about data here, I'm talking about really like bespoke sets of data that isn't available on the internet. So for example, healthcare data, like medical records and things like that. And there are obviously privacy concerns about that, but that's a separate issue that I'm not going to talk about. But if you've got a really nice data set, that perhaps your company's been in business for a long time, and you built up a big data set of healthcare data, what can you do with it and how can you monetize it? So this is something that people are trying to work out. I have lots of conversations about this, and there are a couple of different options. Is that you could license the use of the data itself, so you can effectively give the data to a third party to train machine learning models or do whatever they want to with it. Or another way is that you can train your own machine learning models and then make them available to third parties, perhaps through an API, for example, so an API call, so they can call your models through the cloud. And there are lots of interesting things to be thinking about when you're thinking about trying to monetize data in either of these ways. So it feels on the surface that it might be safer to only train your own models and then allow people to crawl your own models. But actually, trained models, they leak the underlying data every time that they're called. So it kind of gives away a piece of the training data in its response effectively. And that is actually a well-known type of hack. So there's this thing called an extraction attack, where that somebody will bombard a machine learning model with lots and lots of requests in order to pull out all the data that it has. So when we're thinking about monetizing in this situation, you might actually have a payment structure whereby that the user pays proportionately more for the more that they access the model. So if they're only making 10 API calls, that might be quite cheap. But if they start making 100, 1,000, 100,000 calls, that's when they're actually building up, they're taking out all that data from the trained machine learning model. And perhaps at that point that they should be paying considerably more, which is perhaps an inverse model to what you might initially think about. And of course, another way of setting up a payment structure for selling data might be that users have to pay more for edge case queries. So when you've got a data set, you've very often got like a bell curve of data. And it's always these edges, these edge cases that are the most valuable, and it takes the longest to build up the edges. So if you've got a user who's consistently, pinging to try to get information on edge cases, you might start to charge them more as well, because that data is worth so much more. It's harder to get. And of course, if you're actually not going to be using trained machine learning models and you want to license the data itself, you might decide to keep hold of your own competitive edge and your company's competitive edge by holding back some of that edge case data, or selling it separately at a higher premium. And of course, there are well-known options as well for watermarking your data set to detect unauthorized use. So those are some considerations for monetizing data. And like I said, I'm really interested in this. So, if this is something that you've been mulling over and thinking about yourself, then yeah, please do get in touch, because I'd like to talk to you about it. Okay. Okay, so I've just run through relatively quickly there some different ways of potentially monetizing your data, and I'm going to go back to how to really make your IP work for you now, and how to choose what to patent and what to trade secret in particular. So if you want to make strategic patent filings, broadly speaking, you want to be patenting stuff that's going to be either revenue generating, so that it generates you revenue from one of these monetization streams that I've just talked about, or you should be protecting your revenue. So you want to be patenting stuff that's functionality of your products, for example. And another thing is that generally, strategically, you do want strong patents, so patents that aren't going to be vulnerable to attack or revocation. So identifying valuable patents and which ones you should file. So Colin touched on this, so I'm just going to go into it in a little bit more detail. So it's a good idea to look at what's new in your the new outputs of your R&D, and then match that up with what's detectable, and then know what's commercially valuable. So when I'm talking to new clients and they're trying to produce or trying to create themselves a patent filing strategy, I always start by saying, right, let's make an inventory of everything that's new, all of the new features, all of the new products, all of the new ideas. And I concentrate there first because I don't want to miss anything. So sometimes, a really minor, or really not minor, but a small feature can actually turn out to be really, really commercially valuable. And it's easy to overlook if you don't do this methodically. So make a list of everything that's new. Then go through, and annotate, is it detectable? Is it not detectable? Is it detectable? Is it not detectable? And then, though, go through again and say, is it commercially valuable? And how commercially valuable is it? And really, it's this central box here, this confluence of stuff that's new, that's likely to be patentable, that can be detected by third parties, so that they could easily copy it, for example, but that is also really commercially valuable. That's where that you want to be looking first and foremost for patent filings. But of course, when you've identified all these things, there's definitely merit in just carefully going through everything that's commercially valuable, because even if it isn't immediately necessarily going to result in a strong patent, there are often reasons to patent or file patents for commercially valuable things anyway. So if you've got something that's new, and it may not be, so by new I mean that it meets the novelty threshold, so it's just different in some way, but it may not be strong enough to actually meet an inventive step threshold. If it's really commercially valuable, then that's definitely something to consider for a patent filing. And nonetheless, you should always try to patent, your most commercially valuable assets. And even if you come to the conclusion that there's absolutely no hope of getting patent protection, of actually that patent application being granted, it is nonetheless a recognised strategy to file patent applications to that type of subject matter. Because that as soon as you filed it, you can have a patent pending status. And the examination process is a long time. It's 2 to 4 years, as Colin said. And that just gives you a bit of breathing room. You can say that it's patent pending, and then the onus is on third parties to work out whether you're actually going to get a patent granted or not. And that can really deter competition. So that's really good. But if you've got something that's really commercially valuable, you're not really sure if it's going to be patentable, or maybe you do think it's going to be patentable, but it's not detectable. So in this box here, then this is really where that we're in the trade secret realm. This is something you should be considering for trade secret protection. So one of the motivations actually for doing this talk today is that I've seen on LinkedIn various grumblings about people saying that that their IP, IP is just expensive, and it's not actually worth pursuing patent applications at all. I'm pleased to say that's none of my clients, but it's just an observation from LinkedIn. And I think that for those people, it's possibly because that they're not actually patenting in the right portion of this diagram. So very often people will just be patenting things, like Colin said, that are cool and that are new, but don't actually fall within the space of commercially valuable innovation. So in particular, companies can fall into this trap if they have what I call an inventor-led filing strategy. So an inventor-led filing strategy is when your R&D team comes to you and they say, "Oh, I've done this really cool thing. It's so great," and then they say, "Yeah, okay, let's file a patent for it." If that is your patent filing strategy, it's quite it's highly unlikely, in my opinion, to actually really work for your company. You've always got to take a step back and you've got to say, right, what have they done? Which products does it relate to? Is it going to be commercially valuable to us? So you don't want to be just led by your inventors. You've got to be led by the business. It's got to come from the other way. This is particularly important when you're thinking about putting examples into patent applications. So if you've got an inventor who's invented a really cool machine learning model, for example, and they've applied it to a really narrow field, such as like detecting prostate cancer in medical images. If that's your only example in that patent application, then you might end up reducing your potentially large monopoly to that really tiny example that's come from the inventor. And you need to take a step back and, as the business, say, no, what are the broader implications of this? How can I really extract the maximum commercial value from what this inventor has done? So listen to your inventors, but ultimately it's the business that sets the IP strategy. Just one final, I think this is the final point on this, is that you might also want to defensively disclose. So if you've made the decision that you're not going to be filing a patent for something, so you might have something in this box or indeed in this box, it's new, but it's not commercially valuable to you, you're not really interested in it, you may or may not use it in future, you might make the decision to disclose it so that nobody else can get a patent protection for it. The worst thing to do is to develop something and then have to take a license from somebody else further down the line. So another patent strategy is to create a thicket of rights. So by this, we want to if you found something that you want to patent and it aligns with your business strategy, you're then looking at, okay, how can I really block the competition? Do I need one patent? Do I need a bunch of patents? Can I supplement this with utility models depending on which jurisdictions you're in? What about designs and trademarks? Let's really create, a really strong barrier against the competition so that nobody else can enter the same market space as you. And just a quick point on trade secret management. So if you remember my 3 circles, if we've got something that's not detectable and it's really highly commercially valuable, that's like prime trade secret space. But with trade secrets, in a lot of cases, less is actually more. So at that conference that I mentioned, the number 3 kept coming up. 3 is the magic number. Lots of people were saying that it's unrealistic for an organisation to keep more than perhaps only 3 secrets. So if you remember that example that I gave about the production line, it's like how many screens can you realistically have in a company? Like, how many door panels can you have and how many secrets can you really keep? And perhaps actually, 3 really good trade secrets that you really look after is actually much more valuable to your company than like 100 or 1,000 trade secrets. And if you're in the realm of having 100 or 1,000 trade secrets, then perhaps actually they're not really trade secrets at all, and they're more kind of like company confidential pieces of information. So we're coming to the end of the session now. I've just got a couple more quick points. To make sure that you're getting the maximum value from your patent and trademark portfolio, you really need to link each patent or IP asset back to the business plan. So if you've got a patent that protects a feature on product A, how much is that product worth to your business? And you need to be comparing the revenue stream compared to the cost of a competitor coming in, and what's the risk of them eating into that revenue stream. And then you need to compare that to a cost of patent filing, and hopefully you'll come to the conclusion that that patent is actually really valuable because it's protecting that revenue stream. And then you want to be thinking, can it create revenue in its own right? So can you monetize it in any of those ways that I talked about previously? And how much is it worth if you wanted to sell it, license it, or in settlement scenarios? And this should enable you to place a more concrete value on each IP asset that you are maintaining. And you need to prune rigorously. So either sell or dispose of assets that don't align with the business plan or are a financial drain. So if you make that comparison that I said on the last slide, you can come to the conclusion that actually it's just costing you a lot of money, then ditch that one. That's not the right one. Then look for the strategic ones that are really protecting your commercially valuable assets. So this is just coming to the end now. So I'm just going to give a quick summary. So link your IP assets back to revenue streams to effectively evaluate their worth. And high worth patents, in particular, are generally associated with features that are of high commercial value products. Then they're new, they're valuable, new and patentable, and they're detectable. And if you're one of these people that's questioning the value or the utility of your patent portfolio, you may well have not actually performed this value assessment properly. You might have obtained the wrong type of protection, or you might have been working in the wrong region of that 3-circle diagram that I talked about. You might have accidentally fallen into the trap of patenting something that's cool or driven by your inventors. So I hope that's helpful. Here are our contact details. Colin and I are both on LinkedIn. We like to make friends, so please do link in with us and follow up with us. Thank you very much.
Thank you very much, Kim, and thank you very much, Colin. We have a minute before the end of today's session, but I think we can fit in one question before we let you go, because it's a fantastic opportunity having you here. But before I ask that question, I just want to say thank you very much to both of you for your time today, for your insights. It's been a fascinating hour, so thank you very much. So our question: when guiding clients to IP counsel, is there a general consensus about what should and should not be patented? Thank you.
So hopefully I covered quite a few of those considerations just in that last section of the talk there. I think I would say if it's something that's important to your client, just don't worry about like the technology area or whether it's potentially patentable or a patentable subject matter. Just get them to talk to the patent attorney. It might be that we can tease something out no matter what it is. If you want to go a more slightly deeper answer than that, then generally you're asking your client, is it new? Do you know of anybody else who's done this on the market? And in Europe, you need to be asking, what is the effect of the thing? Is it something that's technical? And if it's something that relates to a technical field, then no, it may well be patentable. In Europe, if it's something that's relates more to kind of like a business method, then no, that's much more difficult to get patents granted for in Europe. But nonetheless, if it's important to the client, it's still worth just checking in with a patent attorney.
I would point people to Kim's nice Venn diagram.
Yeah.
Brilliant. Well, thank you very much for that. And as I say, thank you very much for your time. It's been a real pleasure to have you with us. Thank you very much to our audience as well for being with us. We appreciate your time. Kim, Colin, I'll hand over to you for any closing comments that you might have.
Yeah, thanks, Dan. Yeah, hopefully it's been useful and people have been able to take a couple of tidbits away. Yes, I think I lost count of how many times Kim and I said the words commercial use, commercial value. That's the thing to bear in mind when developing your IP strategy, always with a laser focus on the commercial applicability and how it fits in with your business plan.
Excellent. Brilliant. Fantastic place to finish. Thank you very much, everyone. Have a lovely rest of your day. Goodbye.
Thank you.